Happy Mediation, Family Mediation Week. And welcome to you all. As I said, it's great to see so many people joining us for the launch today of Family Mediation Week. I'm Stephen Burke. I'm the chair of the Family Mediation Council, and it's my pleasure to welcome you this morning. This week, Family Mediation Week promises to be bigger and better with some great webinars and events, media coverage, and awareness raising. Many of you will also know that last Thursday, the Minister for Justice, Family Justice at the Ministry of Justice, Lord Ponsonby, announced that the Family Mediation Voucher Scheme will be extended for another year to March 26. So that was great news, a great way to start this year's week. The government is now conducting its spending review for the following 3 years and collecting evidence about the benefits and impact of the voucher scheme. So the FMC will continue to provide data and ammunition for the spending review. This morning, Helen Anthony is going to be talking about funding in her update shortly about the state. She's also going to be talking more generally about the state of family mediation and the FMC in 2025. We've got some big plans ahead for this year, not least the 10th anniversary, celebrating the 10th anniversary of the FMC. Sarah Manning is going to tell us more about Family Mediation Week and what's lined up. And then finally, Anna Sinclair will tell us about the Pathfinder in Wales. And I hope also we'll have some time for your questions. If you've got any questions, please can you put them in the chat? And if there's any general comments you want to raise as well, please put those in the chat as well. Any particular issues or questions. So without any further ado, it's my pleasure to introduce Helen Anthony. Helen's the FMC's Executive Officer, who's going to talk about family mediation in 2025, and I'm sure much else that she's involved with. Helen, over to you.
Thank you very much, Stephen. Thank you, everybody. As Stephen says, welcome to Family Mediation Week. We thought it would be a good opportunity this morning to take stock of where the family mediation profession is with this start of Family Mediation Week, and to look at how far we've come. Sorry, Julie, could you move on to the next slide, please? The FMC is 10 years old. We were incorporated in April 2015 to bring together the family mediation profession with the aim of promoting family mediation for the benefit of the public and to provide self-regulation of the profession. If we think about how far the FMC has come in those 10 years, we've come quite some way. We've established the Family Mediation Standards Board, the FMSB. We've established, as a result, the FMC as the home of regulated family mediation. The standards and the code of practice are central to the mediation profession, and it's difficult to imagine the profession without the standards board and that structure that it provides. Family mediation has become embedded in the family justice system. The court rules require parties to consider using non-court dispute resolution and public funding through legal aid, and the voucher scheme support this. We were delighted, as Stephen has mentioned, that Lord Ponsonby, Minister responsible for family law, announced a year's extension to the voucher scheme at our pre-Family Mediation Week reception last week. And we are going to continue to work with the government to try and secure multi-year funding for that scheme, as well as the future of legal aid. I thought it would be helpful to refer to a comment we've received from a mediator who's sadly retiring in April, because actually when I received this just before Christmas, I thought it summed up the journey that the FMC has been on over the last 10 years. The mediator said that they recalled the very early days and were hoping to progress to acceptance as a profession, and here we are. It's a very big thumbs up from me. On retiring, I see how far family mediation has come on the family law map, onwards and upwards. And I do think that the family mediation profession is now on the family law map. This was cemented to me when my daughter came home. She's 14. She'd been doing some careers work at school, and she said, "Mum, guess what profession the system suggested I go into? It said I might want to become a mediator. I know that lots of people have said to me they want to see mediation as recognised as a profession, and I do think we've made good steps towards that. So we are 10 years old. The FMC thought it was a good idea to see where the public thought we were in terms of profession. And so we've done some polling ahead of Family Mediation Week. Julie, could you move on to the next slide, please? Thank you. So one of the questions we asked says, to what extent, if at all, are you aware that family mediation is an option in divorce or separation to help you avoid court and resolve money, parenting and property issues? We're really very pleased that 2/3 of people who responded to that poll were aware, somewhat aware or very aware of family mediation as an option. A third weren't at all aware or not that aware, so we've still got some work to do. But it's heartening to know that 2/3 of the public do recognise that family mediation is an option. This was a poll carried out by Survation. It was of just over 1,000 adults UK-wide. So it's good to know that the word is out there, and that reflects what family mediators have been telling us as well. You have been telling us that people are coming to you generally aware that it's an option. They're coming self-referred as opposed to through solicitors or the court in increasing numbers. So that's really positive. Julie, could you move on, please? So the next slide is going to tell us about the feedback in relation to people who would choose a family mediator first or a solicitor first. Julie, if it's possible to move on to the next slide, then hopefully that will, thank you, that will show us that 45% of people would still go to a solicitor or a lawyer first, 30% would go to a family mediator first, small percentage would go elsewhere, and some don't know. So we've still got some work to do to sell people the benefits or tell people about the benefits of family mediation. It's obviously very positive that people are getting legal advice. We would support getting that alongside mediation. But we do think this shows that we need to do some more work to explain the benefits, so people think, oh, the first place I would go was a mediator. So it's a really positive position that we're in, but we do have some more work to do. If we can move on to the next slide, please. So some of the challenges ahead are obviously to increase confidence in regulating mediation so that more people do decide to go to a mediator first, or it's the first thing on their mind. We also have a challenge to increase the use of child-inclusive mediation, not as a result of any polling, but because we know that it's valuable for those children, for their futures to be heard in mediation and in when arrangements are being made that affect them. We need to increase the awareness of the benefits of mediation, because obviously people need to have confidence in us. They need to understand the process, but they need to be aware of the benefits of going, what the outcomes were, that it potentially can save them money, that it saves a lot of stress, better outcomes for their children, etc. We also still have some challenges on sustainable funding. It's great the voucher scheme's been extended for a year. As I mentioned before, we need to work on a longer term funding solution, and that includes sustainable legal aid for those on the very lowest incomes. And we need to continue to strengthen the profession. It is great to see so many people here this morning. It's great to see so many mediators getting involved in Family Mediation Week. And we need to continue to support you, to work on accreditation pathways, to strengthen the PPC system, and to provide resources to support you. I am delighted to say that the FMC is going to be having a conference this year for the first time in our 10 years, and we will announce details of that at the end of Family Mediation Week. But it's going to be a good opportunity for everyone to come together to really celebrate what we've done over the last 10 years, and to look ahead to the future and to see how we're going to address these challenges together. So to bring it back to Family Mediation Week, obviously Family Mediation Week contributes to facing all these challenges. It helps to raise awareness, it helps to build stronger links across our profession and those within the wider family justice system. So I'm delighted that Family Mediation Week is here, and I'm going to hand back to Stephen so we can find all about it.
Thank you very much, Helen, for kicking us off today. Um, and some great news in terms of growing awareness about family mediation. Now we need to turn that into action. Um, our next, if you've got any questions to Helen, by the way, please just add them to chat. And a warm welcome to Anthony Matthews, who kicked us off with a comment in the chat. Thank you, Anthony. So our next speaker is Sarah Manning. She was recently recognised in the National Mediation Awards as Family Mediator of the Year and is a partner at Hall Brown Solicitors in Leeds. Sarah chairs the Family Mediation Working Group and will tell us about what's planned this week. Over to you, Sarah.
Thank you, Stephen. So hi, everyone. This is the fourth year that I've been chair of Family Mediation Week, and it's been great to witness its growth each year with the sole purpose to raise awareness of family mediation. I trained as a mediator back in 2012, which was following the introduction of a requirement to attend a MIAMS in April 2011 if you were pursuing proceedings. I believe then, as I do now, that mediation is the future, offering a clear alternative to the adversarial process. Unfortunately, it's taken a lot longer than anticipated for mediation to gain the recognition it deserves as a viable option for separating families. Mediation is less time consuming, reduces hostility, and is more cost effective. And as a practicing solicitor, I understand that some cases necessitate judicial intervention, but so many cases currently clogging the court system could be resolved outside of it, allowing the courts to focus on matters that truly require their attention. The purpose of family mediation this week is to raise awareness of mediation among professionals working with separated families and the public. We aim to raise awareness of mediation, its benefits to anyone facing separation, and to consider mediation as a first option. We aim to educate legal professionals about the benefits of mediation and how it can be adapted to not only help with low value matters with little complications, but also as a viable option for high net worth cases with complex issues for both children and financial matters, which hasn't been the case previously. Since our last Family Mediation Week in April 2024, we've seen a significant broadening of the definition of non-court dispute resolutions, now known as NCDR, to encompass not only mediation, but also the methods like arbitration, neutral evaluation, and collaborative law. This emphasises the importance of exploring family disputes beyond traditional litigation, and the new FM5 form mandates parties to actively consider and document their stance on NCDR when filing court applications, with courts now having the authority to impose cost orders if NCDR options are not explored. The change has been welcomed, and I have personally experienced a notable increase in referrals for more complex matters that might not typically be suited for mediation, and it is encouraging to see NCDR being taken seriously. I had the pleasure, alongside Stephen, last Thursday to travel to London for our first ever in-person launch, which was a great success. And as mentioned by Helen and Stephen, it was announced about the voucher scheme being extended for another year, which is excellent news to families going through separation. I've seen personally a higher uptake with mediation as a result of the voucher scheme being made available. This week we have an exciting lineup of free webinars designed to achieve this goal. We are delighted to report strong registration numbers for all the events we have planned this week. These sessions will be recorded and made available on the Family Mediation Council's YouTube channel. And last year's webinars are also still available on the channel, so feel free to revisit them and share widely, as we've tried to cover different topics each year. We've worked to cover a variety and to create a valuable resource. So the purpose of this is to create a valuable resource library that can be referred to, especially by separating families, and encouraging public-facing webinars remain accessible and shareable. This year, we introduced a formal sponsorship package, allowing us to secure much needed funds to enhance our marketing efforts and reach the wider public, an area which we've previously faced challenges with. We extended our heartfelt thanks to all our sponsors. Your support has been instrumental in helping us promote these webinars effectively and have the funds to do so. It's not too late to sign up for the webinars and share the schedule with your clients and contacts. If anyone here today can help spread the word on their social media platforms, it would significantly enhance our outreach. Even sharing on personal accounts can help connect with individuals experiencing separation or those who know someone going through it. I shared something on Facebook the other day on a personal account, and I got 2 messages afterwards about some family relative that they had that was going through separation and asked for more details. So I sent them the webinars that was available. Year after year, we're privileged to have exceptional speakers who generously share their expertise, playing a vital role in the success of the week. Their contributions are deeply appreciated. This year, we introduced a deadline for webinar proposal submissions, and we were thrilled by the overwhelming number of applications. Whilst we sadly couldn't accommodate all the proposed sessions, we encourage those interested in speaking to watch out for the submission deadline later this year. We're excited to present a fantastic lineup of webinars this week, and today's programme begins at 10:30 with a session on hybrid mediation aimed at lawyers. Elaine Richardson and I will explore how mediation can be adapted with the involvement of other professionals. And then later today, we have Sarah Jane Rindle and Sushma Kotecha, who will host a session for the public on the benefits of attending a MIAM, followed by a 2 p.m. webinar on kinship care and mediation. This session's tailored for local authorities, CAFCAS and mediators, and will highlight how mediation can support cases where children are cared for by non-parents. This week continues with a diverse range of sessions for lawyers and mediators. Some of the highlights include on Tuesday, we've got mediation research findings, digital solutions to improve the separation experience, the importance of child-inclusive mediation to arbitration, and one on cultural and religion in mediation, and considerations for media where there's issues of domestic abuse. We've also got public focus sessions throughout the week, the flexibility of mediation, where mediation is possible with a narcissistic partner, and the concept of child-inclusive mediation. We have some specialist webinars that are tailored for domestic abuse advisors on family separation and also others to CAFCAS officers. Resolution are also hosting a training session titled Unlocking the Power of Mediation, a guide to maximising success in the mediation process. This session is particularly valuable for solicitors who may be hesitant to suggest mediation due to a lack of understanding, and it will explore how to best support clients through mediation and the role of solicitors, ensuring the process stays on track. With the growing emphasis on non-court dispute resolution, it's crucial for lawyers to actively present mediation as a viable option to clients and avoid criticism at court. Building on previous year's success, we continue to encourage everyone to make a pledge to raise awareness of family mediation throughout the year. Previously, I've committed to promoting mediation in schools and engaging with local domestic abuse advisors, initiatives that have proven highly impactful. This year, I pledge to share our recorded webinars widely and encourage others to do the same. I look forward to seeing your pledges throughout the week, and let's each aim to reach at least one other professional who works with separated families to educate them about mediation, and together we can increase awareness and make a real difference. We're also hosting several in-person events this week. Tuesday, we've got Family Law in Partnership is hosting a coffee morning in London. On Thursday, Reading Family Mediation will host an evening event featuring a role play of Meet Maya and information on different types of mediation and a Q&A. And this is the first time we've done anything like that, so I'm quite eager to see how successful it is. And then on Friday, I'm hosting an in-person evening event to bring everyone together locally as family mediation concludes. It's always a wonderful opportunity to reflect on the great work we've accomplished together and network. We have a dedicated LinkedIn page for Family Mediation Week and encourage you to share our posts. The Family Mediation Council also remain active on Facebook and X. Please tag us in your posts using hashtag Family Mediation Week so we can celebrate your efforts. And if you have anything that you want to send through, please do so. Throughout the week, we'll share blogs and resources, and we encourage everyone to share it. If everyone would like to share anything they are doing, or any events or any news articles that you get, please let me and Helen know what's happening in your local area. We've also sent press releases through the FMC newsletter, and it would be great if you could reach out locally to share these. Thank you for your ongoing support, and I hope you enjoy the webinars that we've got set up for this week. Thank you. Pass back to you, Stephen.
Brilliant. Many thanks, Sarah. As you can see and hear from Sarah, there's a huge amount planned this week, and so certainly my thanks to the team, you and your team, Sarah, for all the work that you put in to make it happen, and to all the team at FMC. As I said, a huge amount. Now, our third speaker had a slight technical hitch, so before Anna Sinclair gets back to us, we're going to take a few questions. I haven't got any questions in the chat, but we've got 100 mediators in the room, so there must be lots of people who'd like to say something, even if it's just say hi, great to be here or whatever. But does anyone want to make a contribution or ask any questions to Helen or Sarah about Family Mediation Week and Family Mediation Council? Any contributions, please? Can I just ask you, Helen, perhaps a bit more about the announcement that the Minister made last week about extending the family voucher mediation scheme. Any more detail on that and what it will mean and what we need to do going forward?
Yeah, so the voucher scheme started in 2021 and it hasn't, it's always been extended by a relatively short amount of time. It was set up as a temporary project. We thought it would last no more than 6 months. And so it was great that it was then extended. What we have been doing with the Ministry of Justice is trying to look at the data that mediators collect as part of the scheme to show how valuable it is. And the Ministry of Justice came to us sort of towards the end of last year and said that they knew the value of mediation, that wasn't in doubt. But what they haven't yet got is the data to demonstrate that the value of the actual scheme in terms of putting the public money into mediation at this stage is I suppose worthwhile for the long term. That there is a general understanding that the voucher scheme works, but they haven't got the data to show it. So we have been working with the Ministry of Justice very early on this year to see if there is a way in which the data that can be collected can be improved, and actually to make it slightly easier for mediators as well in terms of the information you submit. And so that was very promising that the Ministry of Justice were looking at that. However, they hadn't got confirmation of the actual funding. I mean, everybody has seen in the news that the government is working very hard to make sure that the public finances are in a good state, and obviously the care that they're taking over the voucher scheme was part of that. They received confirmation just before last week's event that it will be extended for a year. The minister very positively said, "I'm really pleased to announce it's been extended for a year. However, I know you're all interested in longer term funding." And he did say that he was working very hard to try and secure that. So we have multi-year funding for the scheme. So the aim is for us to work with you as mediators over the next 6 months or so to make very hard to make sure we do get that data in, to be able to demonstrate the picture, not just to the Ministry of Justice, but also to the Treasury of the value of the scheme. The really positive thing as well is that the minister knows it's not just about the voucher scheme. He knows about legal aids as well. He knows that it's really important that we look at that. So I think, Stephen, that it was positive from an announcement point of view. We were all very pleased to get that just ahead of Family Mediation Week, and it's great for those families for a further year who will benefit. But what we are going to do is continue to work with the MOJ to ensure that more families can benefit in the future and we have a longer term sustainable system in place.
Thank you, Helen. And he was very upbeat about the value of family mediation last week, and but also very aware about the need for continuity of funding and multi-year funding, and that's really where we need to focus our efforts, including on legal aid. We do have a question from Ruth Smallacombe, but I'm going to come back to that after, because I think Anna Sinclair has managed to rejoin us, and she's our final speaker this morning, and then we'll do some questions. So as I said, our final speaker is Anna Sinclair, who's head of practice for CAFCAS in Wales. Anna's hugely experienced in family justice and has been closely involved in the development and implementation of the Pathfinder model in Wales, which she's going to tell us more about. She's got some slides as well. So over to you, Anna.
Thank you very much, Stephen. And Bore da pawb, good morning, everybody. Apologies for my IT glitch with a forced update, which wasn't very welcome. But yeah, after a very slow 5 or 7 minutes, I'm back. So I'm going to talk fairly briefly about the Pathfinder, which its proper name is the Investigative Domestic Abuse Court. What lies behind the development of it, its aims and what it's testing out, what it looks like in practice, and what it might mean, how it fits in with mediation. So I think some people have heard of Pathfinder, but there's a lot of people saying they don't really know what it is. It's arisen from reviewing how CAP works. So that is the child arrangement programme that we've had since 2014. I assume most people would be aware of that. So the court sends an application to Cafcass or Cafcass Cymru for safeguarding screening, and then there's a first hearing at which parents or parties are encouraged to try and resolve their dispute. And if that doesn't happen, then it sets each case off on quite a long sort of conveyor belt. And it's well known that cases can take, well, it was an average of sort of 39 or 45 weeks in Wales for private law. It's longer in parts of England. And that was one of the issues that when Sir Andrew Macfarlane became the president, he set up working groups to look at how public law and private law were working. And the private law working group was chaired by Sir Stephen Cobb. So he started looking at this. I sat on that group as a representative of Cafcass Cymru, and we thought that CAP could be tweaked and to work better. But then some other work started happening as well. Most notably, the Ministry of Justice put out a call for evidence and set up an expert panel to look at how the private law process dealt or deals with allegations of harm and domestic abuse. And really, it was the findings of that report that were the kind of catalyst for Pathfinder. The government of the time committed to reforming private law, and Lord Ponsonby, who is now the Minister in charge of it, is also quite passionate about doing things better. So the Pathfinder began life in a small way in North Wales and in Dorset as the initial pathfinders that were going to sort of iteratively find a new way to do private law. It's led and funded by MOJ and was developed by stakeholders in the system, professionals and researchers in the field of family justice. And they, as I say, aiming to reform the way that the court approaches family cases, particularly where domestic abuses are concerned. So if I could have the next slide, please, Julie, I'll just talk to the 4 key panels of the Harm Panel report. So this report was published in 2020, and it was chaired by Professor Rosemary Hunter and Liz Trinder and others. And a really long report because they had over 1,000 responses to the call for evidence from all kinds of people and groups about what is wrong with family law. And they distilled all of that evidence down into these 4 key structures that have to be addressed for family justice to be improved, private law justice. And the Pathfinder is built on these principles. So a changing culture from a pro-contact culture, or what's been described as contact at all costs, to putting safety and protecting child and adult victims of domestic abuse first and foremost. Changing the process and the approach in the court from an adversarial one to an investigative and problem-solving approach. And then linked, they all interlink, so linked to that, better use of resources. Obviously, we would like more resources, all of us would, but there's a lot we can do to use our resources more productively. And then the final point, also really important, is about bringing private family law out of its silo so that the approach to families who enter the private law system is coordinated and they're not just viewed in a vacuum and without considering other parts of their life or other agencies that might be involved. So local authorities, domestic abuse agencies, and so on. So if I could have the next slide, then this is just a bit more about how those 4 key structural changes that are needed then map into the aims of the Pathfinder and the key features of how the Pathfinder works. So we started off really kind of in the dark with those principles in 2022, thinking about how we might do things better. And after about a year of trying things out and Ministry of Justice working closely with us in Wales and in Dorset, we came up with, or Ministry of Justice really distilled what we're trying to do and how we're trying to do that. So the first aim is to improve the experience of family justice for everybody, particularly victims of domestic abuse, and improving children's experience of and participation in the process. So that was really recognising that actually going into the family court is quite a brutal process for people, particularly because of this adversarial nature where parents are set up against each other to sort of try and destroy each other's position. And very often children were not being heard. And in the rest of the country where Pathfinder isn't happening, are often not heard. So Nuffield Family Justice Observatory have published some work looking at data showing that only around 40% of children were consulted or had any voice in proceedings, with the aim of CAP being to just try and close the case down at the first hearing before we've heard from children. So that was the first big aim, to change that, and then to deliver a more efficient process that reduces delays. Reducing the re-traumatisation that might be experienced, and often is during proceedings, of having to write statements and then give evidence on things that have happened to you, and also retelling your story countless times through the CAP process as you are kind of processed by a number of people through that system. There's an aim to reduce the number of returning cases through a more sustainable court order, because we know that around a third of private law cases come back in the next 2 or 3 years. And then finally, a multi-agency approach to improve coordination between the family court and agencies. So we've always, under CAP, as part of safeguarding, requested information from police and local authorities as a paper exercise. But there's not been a good amount of coordination and discussion, really, and no account given of, or no regard given to families who are working with domestic abuse agencies and what input and insight they might be able to give us. So the way that those aims translate into some of the key features of the Pathfinder is, rather than this drawn-out process where information's gathered piecemeal over a number of months in a kind of adversarial way, the key feature really is this child impact report. So at the first gatekeeping hearing, when the application arrives with the court will order a child impact report. And that is a much more holistic report than the safeguarding used to be. And it gives the author the ability to decide what information they need to gather on that family, so they can speak to children before the first court hearing in preparing this report. They can speak to the school and they can make the inquiries that they think are proportionate. And this is usually a report prepared by CAFCAS or CAFCAS Cymru, but if a family is involved with a local authority and has an allocated social worker, then more usually that worker will be asked to write that report. So that's using resources better in the system. It means the family's already known and they don't have to start working with a brand new professional, and is more efficient, and so on. So that is a massive difference, and quite radical compared to what's been happening for sort of the last 20 years in family justice, that children could be spoken to before the first hearing, their views and their lived experience goes into that report. So the very first opportunity the court has to consider what should happen in the case, they've got the voice of the child, and the social worker or family court advisor will have also spoken to the adult parties about, well, this is what your child's actually saying to me. So the second major change is a supportive approach to domestic abuse. So Ministry of Justice have funded a pathway, and there are, as part of the system, paid for IDVA services. So that's been done through a tendering process in the Pathfinder areas that we have at the moment. So domestic abuse providers provide a DASH-RIC assessment and safety measures and support. DASH-RIC is the domestic abuse, sexual and honour-based violence risk assessment checklist. So that would identify women or men who are at high risk right now, and allow some safety measures to be taken, and also to provide them with support through the court process. I've already mentioned the inclusion of the child's voice from the outset of proceedings, and that is central to focusing the court. and also giving children their Article 12 rights, which under the cap are really kind of brushed under the carpet. And then finally, everybody working in the system is now trying to work in a problem-solving and trauma-informed way. So trying to think about what's behind people's behaviours, make proper use of special measures, give much better information so traumatised people aren't sort of bewildered by the process that they find themselves in, and reducing the emotional strain on everybody. So the first Pathfinders began in 2022, and then last year, after 2 years, showing that this is actually working really, really well. We haven't got the formal evaluations yet, but the early evaluation and all the informal feedback is positive across the board. And the time taken to resolve cases has halved in Pathfinder areas from kind of 39 weeks to 18 weeks. Fewer cases are coming back so far, although it's early days. So after a successful first 2 years, further Pathfinders were launched in South East Wales and in Birmingham. And Ministry of Justice has committed, subject to the formal evaluation and funding review and so on, if there's funds, they do intend to roll this out as being the new way to do private law sort of over the next 3 to 5 years. And in Wales, we are preparing for a launch so that the rest of Wales will be covered. So this will be what private law is in Wales, which is really exciting. So everybody's finding this such a better way to work. Can I have the next slide, please, Julie? So just quickly, just to kind of show this in another way of what the process actually looks like. So it's very short. So stage 1 is information is gathered and assessed, and that culminates in a child impact report being sent to the court in a timescale of around 6 to 8 weeks. And then we have, I just highlighted there, a role, which is a new role called a case progression officer. So that is a role in the court in HMCTS to keep track of the case and make sure it doesn't get lost, which doesn't sound that revolutionary, but, you know, as people who've worked as solicitors will know, in business as usual, cases can just end up getting delayed. It's a really common experience that we would write a Section 7 welfare report into a hearing that gets adjourned, and then maybe 7 months later we're asked to do an updated report because it didn't get listed and the parents have gone to court and said, well, the child's views have changed now. So yeah, revolutionary that a case progression officer actually keeps track of the cases and makes sure the information is needed, that's needed is gathered. And there's a really good, in Wales at least, and I'm sure it's the same in the English Pathfinders, a really good liaison between our managers in Cafcas Cymru, so we can email a dedicated email address and say, please, could you look at this? There's something about this that is missing or needs to be dealt with. And also that's a really effective way to make sure any case that came to Cafcas Cymru, and then we find out that the local authorities actively or heavily involved, that we can transfer that very efficiently. So that's stage 1, culminating in a child impact report. That the aim is to give the court all the information it needs about the child, their circumstances, the family, and some recommendations of a safe way forward. And then the court can decide what to do with that case. So 3 things really. Quite a few cases are being resolved on paper at that, what's called the second gatekeeping, or the safeguarding gatekeeping, which is where a judge and a magistrate will sit and look at the report in a kind of timetabled way. So there's a day a week or a couple of days a week they do that. So they can make a final order if parents or parents' carers have been assisted to reach an agreement. And if they make a final order on paper, there'll be a right to reply within 7 days. And we're finding maybe like about 30%, we think, of cases are resolving at that point. And then otherwise, if it's not resolved, the case will either be listed for a decision hearing, which is conducted using a problem-solving approach. So maybe the parents haven't reached agreement, but the issues are narrow, the safeguarding issues, there either aren't any or they can be managed, or the family court advisors recommended how that's done. So a lot of cases there are resolving at that decision hearing. It's, we've got the information, we're not messing about, we're making a decision here. Judges describe it as magic, which sounds unjudge-like, but they're saying, when they have that information, it's very clear, they can have a conversation with parents, focus on the child and help them reach agreement, much more than a adversarial hearing that upsets everybody and kind of leaves the family in a bruised and worse state. For high-risk cases, because they are still there, it's not a kind of magic bullet that's going to resolve everything in one hearing, then there's a case management route. So if a fact find is needed, if more evidence is needed, or if a Rule 16(4) guardian is needed to represent the child, then the case will be go into that case management route, directions made and listed for a directions hearing. Even there, what we're finding historically, if a child became subject to a guardian appointment, those cases in Wales were lasting an average of kind of 80 odd weeks. And it was usually almost a year before a guardian was even appointed, because cases just kept getting kicked down the road and relisted and adjourned. But if we need a guardian, that's usually appointed in kind of week 7 or 8 at the second gatekeeping. And then so much of the groundwork's been done that those can be very focused appointments on what the child needs, and the child doesn't end up getting lost in litigation. So that is the process. And then I've just put a note at the bottom about children being listened to and their views and experiences better considered. When we started, it was about children's wishes and feelings being ascertained earlier. But as the models developed and as more research has been done in this area, particularly by Nuffield Family Justice Observatory, it's become clear to us that children need to do more than have their wishes and feelings ascertained. They need to feel that they can participate or be given that choice to have an input into what happens. So that's about better information, being asked how they would like to be involved, and being given the outcome, because there was some research showing that a lot of children were never actually told what the outcome was. So we've had some lovely practice in Wales of judges writing letters to children, which has been really positively received by the children and the judges, really, to kind of make that child more real and bring the process to life for them. So just very quickly then, the final slide is just about where mediation fits in. If I could have the next slide, Julie, there we are. So the Pathfinder is the practice direction, should anyone want to go and read that, is 36Z pilot scheme, and that suspends practice direction 12B cap in the areas where Pathfinder's running. And if you look at practice direction 36Z, it references to mediation are absolutely peppered throughout it. So there is the requirement to attend the MIAM unless there's an exemption. But a whole section to parents about what mediation is and why it can benefit. It's just not that accessible to parents, though, if I'm honest. How many parents are going to go and read 36Z? So I think there's, some more awareness raising to be done. And then, so it says in various places throughout the proceedings, the court will consider whether and the extent to which the parties can safely resolve some or all of their issues by means of non-court resolution. And we do have a Family Justice Board priority is to reduce the number of families coming to the family court by 10% is the target. And to date, we're not really seeing that, although Ministry of Justice is working in that space, as you know. So what I would say about what we're seeing on the ground is really not many cases being adjourned partway through to send families to mediation. And really, I think that's because that process is so much quicker that the judges would think, well, you know, we've been here 6 to 8 weeks. We've now got this child impact report. It's very clear what these parents need to do. So the judges would prefer to have a problem-solving court and get an agreement and make an order, rather than maybe adjourn it for 8 weeks and then potentially not get an outcome from mediation there. I think what we are trying to do is to signpost parents that, you know, this, maybe your child is 4 now, so this is going to work for a 4-year-old, but this is probably a fairly time limited order in terms of your child needs changing. They'll be starting full-time school, they'll be starting secondary school or whatever, and to signpost that next time, instead of coming to court, think about mediation. So we are trying to do that. There was some consideration to kind of having a tick box where at the end of our report template in Cafcass Cymru, we've got various tick boxes to be able to kind of quickly give a one-side summary to the court of what needs to happen. So there's a kind of, we might put in a sort of suitable for mediation next time, or even suitable for mediation now. And ideally, of course, that 30-odd% of cases, and don't quote me on that figure because it's slightly off the top of my head, but certainly a reasonable number of cases that are resolved at that first gatekeeping arguably didn't need to have come to court if it was that sort of easy to resolve. So I think that, yeah, there is obviously a place for mediation. It's probably not within Pathfinder. So once people have made an application, they're quite committed to getting an order. And if people can get themselves to mediation first, then there is a perfectly good sort of opportunity for them to submit a consent order and get that signed off if that's what they feel they need. I think that's all I want to say, so that there's a few minutes for questions.
Thank you very much. Thank you, Anna. That sounds encouraging, although quite a lot of lessons and learning going on. So the Minister did speak very enthusiastically last week about the Pathfinder model. So all power to your elbow. We've got, as I say, a few minutes for questions. If there's anything you want to put in chat, please do. A number of people have already put some comments and questions in the chat, encouraging noises around domestic abuse in relation to the Pathfinder. A question about for Anna in relation, is there a similar process of practice direction 36Z in financial cases, please? So that's a question for you, Anna.
No, it's just Children Act applications.
Okay, thank you. And there are a couple of questions, perhaps Helen, you could come back to in relation to funding, about the scope of the voucher scheme, etc. And Sarah reminds everyone here to make sure you use the hashtag Family Mediation Week. Helen, do you want to say anything else about funding in relation to the questions?
Yeah, so similar to the question about whether there's something similar process to PD 36Z in financial cases, there was a question about, is there any news about extending the voucher scheme to financial cases, and also changing the scope of the voucher scheme or legal aid, or essentially funding for child inclusive mediation. So these points about expansion of the voucher scheme, I think there is work that is being done about potentially having a voucher scheme for child inclusive mediation, a standalone one. You can use the voucher at the moment to pay for child inclusive mediation, but of course if it's being used to pay for other mediation sessions, then it won't extend necessarily to that because of the £500 limit. So there is conversation about having that unique funding, standalone funding for CIM, but again, that's very much data driven. So we are trying to find out what the data we have got and see whether it would be worth trialing that. I say we, working with the Ministry of Justice, obviously, as the funders for that. We have raised the issue of whether it could be extended to financial cases. I think that's less likely at present, mainly because if people have got assets to discuss, then potentially they could afford the mediation themselves. I know that's not always the case, but the MOJ is very focused on the cases involving children.
Thank you very much, Helen. We are reaching the end of our session this morning, so we haven't got any more questions in the chat. Can I end with a round of thanks, just to round things off? First of all, thank all of you for joining us this morning. To have well over 100 mediators join us at various points this morning has been fantastic. Secondly, a big thanks to our three speakers for getting the week off to a fantastic start: Helen, Sarah, and Anna. Thanks for all of those who've been involved in making Family Mediation Week happen, the working group and the FMC team, and of course all the Family Mediation Week sponsors who you can see on this slide here. Thank you to all of them for their funding to make it possible. Can I urge all of you to have a great Family Mediation Week? Please sign up to the webinars if you haven't done so already. As Sarah said, there should be something for everyone this week, so please do sign up, and please keep shouting from the rooftops about Family Mediation Week, hashtag Family Mediation Week. Shout out on LinkedIn, Facebook, and elsewhere about the value of family mediation and the benefits to separated couples, their children and families, and of course our wider society. And as I said, thank you all very much for joining us this week. Let's make it a really successful Family Mediation Week, and we look forward to working with you going forward. Thanks very much for joining us, and bye.